Hello everyone and welcome to today's Mondat webinar in association with Maucher Jenkins to discuss the merits of the Unitary Patent, its value for money and risks. My name is Dan Sampaio and it's my pleasure to be joined today by Hugh Dunlop and Gerrit Schultz. Hugh is a chartered patent attorney, European patent attorney, certified IP litigator and EU IPO representative and author of the book European Unitary Patent, Unified Patent Court, published by the Chartered Institute of Patent Attorneys. Hugh has over 30 years of experience in the patent profession and is a registered representative on the EPO register for over 5,000 European patent applications. Gerrit is a German and European patent attorney, German attorney at law and European trademark and design attorney, and one of the few IP professionals in Germany who is admitted as both a patent attorney and attorney at law. He's very experienced in filing and prosecuting patent applications, handling national and international litigation matters, and representing clients before the responsible authorities and courts at national and European levels, including the General Court of the European Union. Before I hand over to Hugh and Gerrit, a couple of housekeeping items. You are able to submit questions to our panel by typing them into the control panel of the toolbar on the right-hand side of your page. We will endeavour to answer as many questions as possible. You will also be provided a copy of today's presentation after the webinar, and please look out for a link in the chat box. It's now my pleasure to hand you over to Hugh and Gerrit to begin. Thank you.
Thank you very much, Dan, and thank you for those accolades. So welcome to our audience in the United States, North America, and indeed around the world. We timed this particularly for our North American audience, so good morning to you and good afternoon to everybody else. So thank you, Dan, for mentioning. It's about 6 years since I wrote this, the first edition of this book. I had back then thought it would come to fruition rather sooner, but as we now know, the Unitary Patent and the Unified Patent Court will be with us in only a month's time. So, Dan, if we go to the agenda, I'll just go through what we'll be talking about today. I'll talk about the Unitary Patent, what it is, how to get it, the advantages of it. I'll ask Gerrit to talk about the Unified Patent Court and particularly the advantages of the new court. Then there's a little bit to talk about patents as objects of property and about the court's jurisdiction over existing European patents and the possibility of opting out. And then I'll mention who is able to be represented before this court. Aaron, thank you. As I mentioned, the court will open from the 1st of June, and the Unitary patents cannot be granted until the court is available to adjudicate over them. So how do you get a Unitary patent? It's granted by the European Patent Office in the usual way. You'll perhaps be familiar with the process of granting a European patent by the Patent Office in Munich and The Hague. Currently, it leads to a bundle of national registrations. Going forward, it will be possible to register for a unitary registration for many of those states and continue to register for national registration in certain states such as the United Kingdom, which is not a party to the new system. So which states are party to the system? Currently, there are 17. The slide says it may grow by the start date, but I think with only a month to go, that's most unlikely. There's a link there to the list of what those patents are, what those states are, and a map shows you there. And what we're saying here is that we have concentric circles of states in the European system. And the outer circle, we have all the states of the European Patent Convention, which includes states like Switzerland and Turkey, and of course the United Kingdom. And then within that, we have states who are in the EU, but not in the unitary system, states like Spain and Poland. And within that, we have states who have indicated their intention to join this new system, but have not yet joined. And then we have the core 17 states who are ready to go. So take, for example, Ireland. Ireland has indicated its intention to join the system, but has procedural difficulties such as it would need a referendum before it can join. And as I mentioned, Switzerland and Turkey and other non-EU states remain in the EPC. You can get a European patent for Switzerland, Turkey, United Kingdom, but not a unitary patent. We have a handy rank-ordered list of what are the states in the EPC system. You can find it at that link on our website. It's rank-ordered by size, by GDP, and by population for the purposes of deciding where do you get the best bang for your buck when you're covering different states in Europe. And it indicates which of them are signatories to the unitary patent at the outset, and also which are members of the London Agreement and therefore available for reduced translation costs. How do you get your unitary patent? Well, as I mentioned, you get it through the European Patent Office, and all you do is you request at the time of grant that the patent will be granted with unitary effect and treated as a unitary patent, a unitary European patent. That request is filed in the language of the proceedings. There's a form to do it on. You have to be clear that you are the proprietor, you're acting for the proprietor. The proprietor hasn't changed since the application was filed or published. And a translation of the entire patent has to be filed at that time, and more on that in a minute. The when is quite simple, anytime up to 1 month after grant, but it's a hard and fast deadline. There's no further processing. So if you don't file your request for a unitary effect by that date, then you will have a standard European patent. It will be, you can validate it in the various national states. Given that validation in national states has to take place typically within 3 months of grant, and now validation has to take place within 1 month of grant, it's effectively, for all practical purposes, it's a deadline that you need to instruct your European patent attorneys, such as ourselves. You need to instruct us at the time you receive the notice of intention to grant. If you want to go proceed with grant of your patent, that's the time to tell us whether you want a unitary patent and what additional states you want. There are many advantages. Obviously, you get many more states for your money. There will be, I will say, there'll be lower grant costs. Not everybody will say that, but I'll tell you why I believe that to be the case. Because you don't have to validate your patent separately in different EU states. You don't need multiple translations. One simple translation of the entire patent, it suffices for unitary registration. There are pros and cons going forward. The single annual renewal fee is less than the annual renewal fee for about 4 states. I've got a slide on that in a minute. Although if you're used to validating only in UK, France, and Germany, then it will be a little bit more expensive. It's a single object of property, so it's a single registration whenever you sign it. So assignment is considerably easier and cheaper. And you get the benefits of the Unified Patent Court, which Gerrit will tell us about in a minute. I mentioned lower grant costs. Well, we have a simple cost structure. We have a single fee for registering unitary effect, for making sure we meet the deadline and file the necessary documents in the translation. And we're offering a £500 flat fee for the translation of the patent. And we're able to do that because although a machine translation is not acceptable, nevertheless, we've adopted a process through our Freiburg office, through Gerrit's office, whereby we will take a machine translation, augment it with human translation, and have an augmented non-machine translation at a fixed cost. So however long the patent may be, we will spend the same amount of effort in making sure it's an improved translation and therefore not a machine translation. And our firm advice is that this will qualify as not carried out by automated means for the purposes of the recital of the regulation. There's no strict rule to this, so I don't believe the European Patent Office can reject the patent application, and we have already proceeded upon this basis, and we've already had these accepted. By the way, the drawings do have to be included in the translation, so we have had to make sure that drawings are translated into German also. We've chosen German for a number of reasons, not least because we have the ability to do it in German, and for cost effectiveness, and also for, we find that clients are very content to have a translation in German. It can be useful. So, compared to the translation costs, validation costs in, for example, France, Germany, and Netherlands, that comes to approximately £1,500 when you take into account that you have to translate the claims for the Netherlands. And what we're saying is that this total cost comes in at £860 for a unitary patent, so it's cheaper and you get 14 more states for free. And I've got a worked example on this slide, where in this case I've taken UK, France, Germany, and Ireland. Ireland is not a member at the moment, so it comes out in the wash in this example. In this example, validation in UK, France, and Germany is slightly cheaper, £1,500. Unitary effect plus validation in the UK comes out just a little bit more, £1,930. So, as I say, for the sake of £400, you get an additional 15 states. There are slight disadvantages. You are now subject, if you choose a unitary patent, you are subject to the jurisdiction of the Unified Patent Court, and there's no choice about that. It's a new court, it's untried and untested. We believe it will be an excellent court with very well-trained, qualified judges. But as I say, until we've got some history behind the court, we won't know how patent-friendly or how friendly to the public interest it will be. Validity can be challenged and the patent can be revoked across the whole territory in a single action at any time in the life of the patent. So it is a sort of all eggs in one basket option. And this will also be true for traditional European Patent Convention patents that are not opted out after the end of the transition period, and I'll come to that later. One ground of validity that is an invalidity, there's a new ground, is the possibility of revoking the entire patent on the basis of a prior national right. And prior national right is a right that exists in one of the member states only. So I had, for example, a client asking me, well, if we've got a competitor in Denmark and that competitor regularly files Danish patent applications, but maybe doesn't file them all at the European Patent Office, might this pose a risk? Well, it might pose a risk. Prior national rights are not very common. In the course of my career, I've barely ever come across an instance. And at present, with a traditional system, you can file different sets of claims to address the prior national rights. So you have a narrower set in the state where there is a prior national right, and a broader set everywhere else. That will not be possible with the unitary patent. The unitary patent must have the same claims throughout Europe. The European Patent Office has a role in, as I mentioned, in granting European patents, administering those requests, and registering statements on the availability of licenses of right, which I'll mention in a moment, and publishing translations of the patents that are filed, and administering renewal fees in the usual way, subject to the same rules we're all familiar with. And there is a compensation scheme for smaller states with languages that are not part of the EPC, but I'll pass over that. So I mentioned renewal fees once, and here is an example. This is the same example as I mentioned earlier, but now we're talking about renewal fees. They're payable to the European Patent Office starting from the year following the year of grant. The normal provisions for late payment will apply, 6 months and 50% excess. And in this example, I've taken the 6th year. The 6th year is sort of representative year, and I show that for UK, France, and Germany, and Ireland, of course, comes out in the wash in this example, it is marginally more expensive to go the traditional route than the unitary route. Now, whether or not it is expensive for any particular entity depends on your service provider for providing renewal fee services, because these fees, these numbers include a sort of typical service fee for paying a renewal fee. If you have a good deal with a service provider, if you're a large organization with many patents being renewed, you may have different figures, but the tipping point will come fairly soon, and I'll show you in a couple of graphs, a couple of slides time. There's no provision for renewal fees for small and medium-sized enterprises or universities or charities or anything like that. And there is a provision for reduction of renewal fees if you declare that licenses are available as of right under your patent, but it's only a 15% reduction, and I really don't believe it's worth it. So I really think the license of right option is not going to be very popular. And my slide here shows that that the green line shows the cost, just the cost of the renewal fee for the European patent, not including service charges by your renewal fee service provider or ourselves if we pay it for you, for example. And what it shows is that at the outset, the European patent renewal fees were designed to be about equivalent to 4 national renewal fees, of which UK was one. But if you look at the purple line, which shows the addition of a UK renewal fee, you'll see that it's incrementally more. So with your UK patent, you get a great deal extra bang for your buck, a lot of extra coverage for a small amount of extra renewal fee, and you'll see that it's considerably less than a quarter of the green line, meaning that there are other states in there in that unitary patent that are rather more expensive than the UK that make up the average. Well, we're in the lead-up period right now. We have been since March. We have been filing provisional requests for unitary effect. As I mentioned, we've been filing the translations. We've been making sure we understand exactly what may or may not be required, and those will be granted as unitary patents after the 1st of June. We have also, some of these will be subject to previous requests we filed to delay grant up until after the 1st of June to allow this to happen. And in this period, we've been checking that the party requesting unitary effect is indeed the party that owns the patent, and the same for the party who's electing to opt out, which I'll come to in a minute. That there's been no change of ownership since the patent application was filed or since the registry was last updated, because it's not always the case that the registry shows the up-to-date ownership information. So that's the process to get one, and I'm going to ask Gerrit now to talk about the Unified Patent Court, its structure and its advantages. Gerrit, you'll have to unmute.
Thank you, Hugh. So as my colleague has already mentioned, the Unified Patent Court will open its doors very soon. So it is, we are really excited about this in Germany and in Europe, and I think it's a very interesting organization for all clients all over the world. It's completely new. It is. It will deal uniquely with European patents, with standard patents, and with the patents having unitary effect. It will not only be the infringement side, but also the revocation side, it is set up as an intergovernmental organization. So you might have wondered. So it's not an EU directive or an EU regulation that was implemented here, because originally also other countries should have joined, but the European Court of Justice, they demanded the primacy of the reunion law. However, in fact, the the European Court of Justice, they will not have the last word. So only in very few cases, occasions. So for example, when competition law is affected, or when the enforcement directive is affected. So in very rare cases, the European Court of Justice might have a word in those patent proceedings. But apart from those special situations, the patent court, the Unified Patent Court, will deal with everything on their own. What is new for many countries is that there will not only be legally qualified judges, but also technically qualified judges, not only in the revocation proceedings, but also in the infringement proceedings, which I think is very important, because they can really bring expertise into the proceedings and not necessarily have to rely on expert opinions. It is basically a complete new procedural rules were set up, and a new set of remedies were set up. It combines common and civil law traditions. And so what they were looking at when it was set up, what remedies exist in different countries in Europe, what means of evidence exist, and they put everything into a basket, and now you have basically a shopping list of all different kinds of remedies, the means of evidence, which can be really useful when you want to get your right. The court will be set up as a 2-instance court. So not 3 instances, just 2 instances. Keep it simple. So there's a first instance that will consist of local and regional divisions. And we have a central division. We'll talk about this a little bit, why this is the case. And then there will be a second instance, the Court of Appeal in Luxembourg. So there are local, in the first instance, there are local divisions. The local divisions will be placed in each state, and it can have, there can be up to 4 local divisions in one country. So depending on the caseload, there might be less or more local divisions. As we have in Germany, the highest caseload, we will have, Germany will start with the maximum. I think we're the only country which will start with 4 local divisions, and they are situated also in the locations where also currently the most important divisions are placed, such as Düsseldorf. And for countries which are smaller and who do not have so many cases, they can they have set up a regional divisions, like for example the Nordic Baltic regional division, which comprises Sweden, Estonia, Latvia, and Lithuania, who have one common regional division. And the central divisions, it will be shared between Paris and Munich, as London is not part of it anymore. It's currently the case that what had been allocated to London will now also be dealt with in Paris. So most cases will be dealt with in Paris, some in Munich. If you want to bring a lawsuit before the court, you can bring it before the local or regional divisions in the state where the actual certain infringement has occurred, or where the defendant is resident or has a principal place of business. If you don't have a place of business in the contracting in one of the states, for example, if the client is in the United States, then this client can be sued before the central division. So here comes, that is important why you need a central division. There's an important option for the new system in comparison to the old system where you only have had the national courts to decide on. Because the member states, they can by themselves say, open the proceedings to the official languages of the European Patent Organization, which is English, German, French. They can, if they want to, and you can also agree with, between the parties can agree together with the board to use the language of the patent. So this can be really useful because if you have, you might have an application in English, and so far, if you wanted to have a lawsuit in Germany, you would have to translate many documents into German. And with the new system, you will have the possibility to just use English as the language of the proceedings, if also the other party agrees to this. And some translations of the patent might be required. Hugh already talked about this, that their machine translations are not sufficient, but one can find solutions to also rely on machine translations to make it simpler and not to bring the cost down. So there are all different kinds of remedies, as already said. So when you look at the procedural rules, it says, okay, the court may grant an injunction. So what does it mean? It most probably will mean that the court will, in most cases, grant an injunction. Only in very rare cases, an injunction might not be granted. But if you have your standard patent infringement case, this is a must. It can be permanent or provisional, so depending on the situation. And other decisions on the merits are, so when you look at damages, this is a system which we also use in Germany. You have different, being the patent owner, you have different possibilities how you wish that the damages are calculated. So the easiest is always just to say, okay, I want to calculate it according to a sort of a license analogy. You just have to find a license percentage that might fit. But you can also ask for damages. You can say, okay, I have lost quite some money by this, and then you can try to get to do the calculation based on this, but you have to provide to the court probably quite some information about so that this can be calculated. Or you also have the possibility to say, okay, I want as damages what the other party has gained from this. So there you have these three different options of calculations, and the rules say it's the court who can basically decide, but the practice will show whether it will be the patent owner who can decide on this, as we do it in Germany, or whether whether the court will follow this, or whether the court will have a word on this. And I mean, most legal systems will have, in the meantime, that you can also have the possibility to get information about not only the price and the quantities sold, but also about the distribution channels, which can be really useful to find who is behind the infringement, behind an infringement, basically. And you have also different kinds of corrective measures. I would like to focus maybe on one measure on the next slide. And okay, when you look at so you have provisional and protective measures, and especially the production, the inspection orders, and the production of evidence. And you have one situation which can be really useful. So that is, so you have situations where you know there is someone who probably infringes your patent. So you have some indication about this, but you don't really know. You have indications. You don't have proof to this, so you cannot really sue this company. And but you have an indication, and you know there is a machine which is behind a factory. And if only you had, you would know how this machine works in the factory, you would have enough information to sue this company. So this is a situation where the court could give you an ex parte emergency measure and give you the possibility to inspect the premises, go to the premises without prior knowledge, and the other party doesn't know about this. So this can be really powerful. So I had a couple of these proceedings, and not with the here with a new system which is set up now, but with our system in Germany. And it is basically, when you're a patent owner, it's extremely useful because it's basically low risk, because there's basically no damages that can occur if you just have a look at the premises. You go there, you have a look at the machine, and then you have an expert who is looking at whether it's a patent infringement or not. There's not the production can go on, and you do not have to fear that in the end you will have to pay damages to the other party. But you can collect information and then decide whether you want to sue this this company for patent infringement, or whether you find a solution, an out-of-court solution in this situation, which also occur very often. To protect the other party, there's a person which is appointed by the court. So this is who will go to the premises, and as an attorney, you will have the possibility to go with this appointed person to the premises, but you're not allowed to talk about this to your client. So that's really a strange situation. You know about this, but you cannot talk about this until the court says, now you can talk about this because the infringement has been proven by in this situation. The procedure will be set up to be very quick. So it should be done within 12 months, and there will only be a one-day trial. The written procedures is supposed to finish within 9 months, just the standard statements of claim, defense, reply, and rejoinder. And then there will be an interim procedure to prepare the oral proceedings. There might be settlement discussions in this interim procedure. There might already be some witnesses and some questions might be asked to witnesses already, and the court might say what they think are the decisive points to really be able to focus in the oral proceedings on the important points, and the oral procedure will normally be done then in a single day. They've changed now the rules, so now everything can also be done by video. Also, the witnesses can be asked by video, and also the proceedings can be done by video, which can be really useful, especially when you are not in this place in this country. So there's, with the new system, interesting new options, because so far it was often that a national patent lost its right its effectiveness once a European patent was granted. So this changes now, and you will have a coexistence not only between the national and the unitary patents, but also between the national and the standard European patents, in case you decide that you stay within the new system with the European patent. So if you have a national patent and you can have the same patent in the European system, and then you can decide then later on whether you want to use the national court or the Unified Patent Court, which gives you more options. So I will hand over now back to Hugh, who will talk a little bit about the validity. Thank you.
Thank you, Gerrit. Very good. So, so indeed, as I mentioned earlier, the unitary patent, and now, of course, a bundle of national patents that are subject to the jurisdiction of the new court, can be decided as a whole to be valid or not, to be revoked or to stand. And this can be done either as a counterclaim for revocation, counterclaim to an action for infringement, or as a separate action in its own right. And as Gerrit mentioned, one of the purposes of the central division. Well, a key purpose of the central division will be, if there is a counterclaim for validity, then the central division will be responsible for validity, because the system is set up so that we don't have regional divisions who are perhaps less experienced taking a decision on for whether this patent stands or falls as a whole. It's a major decision for the life of the patent. And the usual grounds apply, plus the possibility of a conflicting prior national right, which I've already mentioned. I'll just stay on that side for one moment. If the grounds for revocation do affect the patent only in part, in other words, if it's partially invalid, the court must give the patentee the options to amend it to make it valid. This is not always the case in courts, certainly not in the United Kingdom. In the United Kingdom, the court will only grant you permission to amend your patent to make it valid if you haven't unduly delayed in the face of prior art that perhaps you knew about. If you've been sitting on an invalid patent for too long, the court might not allow, the UK court might not let you do that. But this new court will allow you to fix your patent if it's broken. And yes, the next slide shows some price comparisons to show that it's very good value for money. In terms of court fees, the fees were actually set about 5 or 6 years ago, I believe. They were set at that time to be equivalent to the court fees in Germany. Since then, court fees in Germany have been put up year after year, but the administrative committee hasn't changed the schedule of fees for the new court, so it's actually in terms of fees, it's relatively cheap. It's just slightly cheaper. And the loser pays. So if you lose, you pay the winner's costs, and the recoverable costs are set at a maximum. There's a sliding scale of maximum recoverable cost. The scale is determined by the value in dispute. The value in dispute has to be set in the interim conference by the court. It has to be decided, well, what is the value of that is in dispute, and that determines the recoverable costs. In the case of a revocation action, a pure revocation action, the fees are 20,000 euros, and that's set, that's fixed. It doesn't change according to the value of the patent. So, relatively speaking, you can recover your costs if you win, and your fees are not any higher than you would experience if you're litigating in Germany, for example. So just to sum up part of what we've talked about so far, the title of this webinar was a step further towards harmonization of patent law in Europe. And of course, with one court, we have harmonization in the sense that we will have fewer courts taking contradicting decisions, which has been the case in the past. And there will always be the possibility of diversions of law if you have different courts taking different decisions. But with a unified court working in step, we will take one significant step towards harmonization. One area where there is no harmonization is that the unitary patent will be treated as an object of property like any other national asset, like any other asset. It will be treated as an object of property by the national courts, just like real estate or any other property. There is a set of rules on the next slide which determine what court has jurisdiction. This is not exclusive. This is to say that there must at least be some court that has jurisdiction, even if there may be others. And it goes like this. If there's one applicant, applicant A, and applicant A is resident in a member state, participating member state, then that state, the law of that state applies to the ownership dispute and inventorship disputes. If A is not resident and does not have its principal place of business in a member state, then we ask ourselves, I'm going to skipping across two triangles there, two diamonds, does it have any place of business? Does it have a presence at all? And if there's any presence anywhere in the 17 states, then the law of that state can apply. But if it has no presence anywhere in the 17 states, then by default, the law of Germany and the courts of Germany can decide the dispute. If there are two applicants or three applicants, if there are two applicants, applicant B, then you ask, is the first applicant resident in the 17 states? If not, you ask yourself, is the second applicant resident? And if the second applicant is resident, then the laws of that state can apply. And if it's not resident, then we ask, does either applicant have any presence in any state where the court can take jurisdiction? And if no applicant has any presence, then again, by default, the law of Germany can apply. But this is not to say, next slide, that you can't fight it out in some other court somewhere else, like in the United States, for example. If all the facts and the evidence and the witnesses mandate that it should be that a US court will take jurisdiction, then another suitable court can take jurisdiction. It merely means that there will be a default court somehow, and a series of rules by which a court can take jurisdiction. Now, I've skirted around this next point, which is that the new court will have jurisdiction over existing standard European patents. That's to say, patents that have already been filed and already been granted. And this will be non-exclusive for the first 7 years. So during this 7-year transition period, actions for infringement or for revocation can be brought either before the new court or before a national court. Obviously, if it's brought before a national court, then that national court only has jurisdiction over that, the patent for that state. That's to say the status quo will continue. And the 7-year transition period can be extended by the admin committee, the expectation being that if within 7 years the court has adequate experience and has proven that it has so, and there's no need to extend the transition period, then it will be extended. So that takes us to opt-outs. There is this transitional opt-out possibility. where if you really don't want your patent to be subject to the jurisdiction of the new court, if you prefer the status quo, then you can opt your patent out of that jurisdiction. You notify the opt-out to the registry before the end of the 7-year period, and it applies for the interpretation. This generally accepted interpretation is that it applies for the entire patent across all the states for its entire life. We have been expecting hundreds of thousands of patents and patent applications to be opted out. When I last looked about a week ago, there were about 20,000 so far opted out. We ourselves are doing that right here. One of our paralegals is sitting at a station here, filing opt-outs as we speak. And I'll talk about the pros and cons in a moment. Once opted out, it lasts for the life of the patent, but you can opt in again. But you cannot opt out and in and then out again. We have a website there, a web page which goes through all the pros and cons, and I encourage you to look at that if you're thinking about opting out. But I'll give you 2 slides now on some sort of high-level advice. Firstly, if you've only designated the UK, France, and Germany, which is very common, a lot of European patents exist only in Europe, UK, France, and Germany for various reasons, then you're probably better to stay in. The new court is probably a better venue than France, probably quicker and more predictable. And the UK is not in the system, and the system is very, very similar to the German system. So there's no real benefit in not staying in. Bear in mind that if somebody starts a national action before a national court, then you cannot opt back in again. You cannot opt back in again. You cannot withdraw your opt-out. In the case where it's UK, France, and Germany, it's probably not a big deal. But if you've got more states than that, if you've got Italy and other states, Belgium, and you don't want somebody to file a revocation action against your patent in one of these states, or a declaration for non-infringement, and effectively torpedo your entire patent. I don't want to overemphasize the concern about central revocation. It's not a mere extension of opposition. Opposition in the 9 months after grant is still applicable. Opposition is cheap, it's quick, and it's a great opportunity to take a pop at your competitors' patents, and I highly recommend it. It's only €860 fee, plus your Chinese fees to put together the arguments and evidence, and you can do it in the name of a straw man. You don't even need to put your head above the parapet. Opposition is quick, cheap, and low risk. Central revocation, there are risks associated, and there's a link there to expand on that point. Now, if on the other hand you've designated many participating member states, if there's a lot of designations, then you might want to shelter that patent from central revocation. Or if you've got a competitor who files national applications in a particular member state, so, giving rise to prior national rights. The example I mentioned earlier about a competitor in Denmark, for example. There's a possibility that your traditional existing European patent, if adjudicated by the new court, could be revoked as a whole, even in the face of a national right. I think that's more theoretical, but we'll find out. We'll find out when the court starts. Generally speaking, there's an expectation that if there's a prior national right, that you can carve out that state and save the patent from central revocation. So all being well, you have the option to opt back in again later. Don't rattle sabers before you opt back in, because you might be torpedoed. And again, more on that link. So briefly, we've got about 10 minutes to go, and I've only got 2 slides left, so we have a little bit of time for question and answer. Parties must be represented by lawyers such as Gerrit, lawyers who are authorised to practice before a court of a contracting member state. Gerrit is a Rechtsanwalt, an attorney at law, and he needs no further qualification. Parties can also be represented by European patent attorneys, such as myself, who are entitled to act as professional representatives for the EPO, and who have appropriate legal qualifications, which I have. And in fact, all Maucher Jenkins partners have the necessary qualifications, and we are registering ourselves. I myself am already registered as a representative before the court, and many of my partners have already done that. So there's no nationality requirement. So even though, well, as a matter of fact, I'm British and Irish citizen, so I'm not bothered by the nationality requirement. But even a non-EU citizen who has had either a UK citizen or indeed my Chinese partner in Beijing qualifies, because he has special dispensation from the president to be a European patent attorney, and he is a European patent attorney with the necessary qualifications, and even he can register. So, so that gives a good body of existing representatives who are able to represent clients before the new court. There's plenty of expertise and experience. If you are interested in registering, please let me know. So just sorry, Aaron, going back one slide. So as I mentioned, we are filing opt-outs, and opt-outs can be filed on behalf of the proprietor without a mandate if you are a representative on the list, such as myself, and that's why we're doing them. But you can file them yourselves if you file a mandate. I wouldn't recommend it. It's a pain in the neck. The system, the CMS system, let's say the court management system, requires smart cards and all sorts. So I really don't recommend it. It has been a terrible learning process to get to where we are, but we're filing them thick and fast at this point. And so the case management system is up and running, and it has its hiccups. It does seem to crash if you try to do too much at once, and it will continue to be quite clunky. But fingers crossed, when the first of June comes, they'll have ironed out some of the issues. Apologies, my screen was out of sync for your screen, Aaron, so I've talked to that side, and I've already talked to the next slide. Which takes me to the end of this presentation. Next slide. Oh, just Maucher Jenkins. Oh, you'll have to click again, please, Aaron. There we go. Is a pan-European firm with offices in Beijing and Shenzhen, China. Gerrit is speaking to you from Freiburg. I'm speaking to you from the UK. We have set up, next slide, we have set up a calendar for you to go in and book 30 minutes online consultation on 3 days next week. There's a link there which will be available to you through the chat. It's there on the chat right now, and also on the downloaded slides. So if you have follow-up questions, you want a one-to-one confidential discussion, feel free to book a 30-minute slot next week, because there's a lot to this. It's coming in a month's time, and we'll give you an update after the 1st of June as to what sort of actions we are filing and other people are filing. And then in due course, when the court starts issuing decisions, we'll give you an update on that. And so the final slide is just our contacts. So, Dan, you could moderate any questions at this point if you wish.
Will do. Thank you very much, Hugh. We have 5 minutes and a couple of questions in from the audience that I think are particularly interesting. But first, before we move on to that Q&A, I just want to say thank you to yourself, Hugh, to you as well, Gerrit, for such an insightful discussion today. Incredibly interesting topic. So thank you very much for your time today. Our first question comes from Daniela. Is this ex parte emergency measure an option for a pharmaceutical company who bases the indication of infringement on an MA grant to a generic? You should be able to see that question as well in your chat.
So Gerrit, that's
Yes.
a question for you.
I can say a couple of words to this. So basically, I mean, it depends whether it's preemptive or whether, so depending on the current situation, whether it is like you say, okay, they might manufacture it already, but they are not putting it onto the market. So basically, there is some flexibility. You have to show to the court that you tried everything to get information about the patent infringement. And so in cases that you have tried everything and you have some indication, but you have some gaps missing, and then the court might give you might grant such a measure. For example, if it is if it's not on the market, but you have the MA grant, okay, it might be the patent might still be might only be valid for a year. So they might have it already granted, but they still wait. So that might not be sufficient. But in case that you can show that normally in other cases they have this that they have directly started within a certain time in other cases, and you can show to them, okay, that happened within a couple of months or always within a couple of months, you might have sufficient information to get this this measure.
Excellent. Thank you very much, Gerrit. The second question we have in from Daniel: is the unitary court and the unitary patent prohibited from ever having jurisdiction over non-European Union countries? If yes, shall I assume all non-EU countries will always be handled the old way?
Do you want this? Yeah, sure.
So this goes to, there is a provision which I'll mention to you, which I've not written about either in this book or on our website, which is the long arm provision of the new agreement. The new court, although it must have jurisdiction over the action in the territory over which it has jurisdiction, it can indeed award damages that extend beyond that territory. And I think that's all I'll say on that subject for now. So it must have jurisdiction for the action. There must be some infringement within the territory, but there is the possibility of a long arm award of damages.
Excellent. Thank you very much, Hugh. So once again, I want to thank you, Hugh and Gerrit, for your insights today, and thank our audience for being with us today. We really appreciate it. And what I would like to ask and what I would like to finish on is just any key takeaways that you want our audience to leave today's session with.
Oh, I suppose one thing we didn't mention is that the reason why we're filing opt-outs fast and furious right now is because one doesn't want to face a revocation action on the 2nd of June. If you've got a key patent that's validated in many countries and it's an important patent to you, then clients are taking the safe option and opting them out before the 1st of June, because if the competitor is waiting in the wings, itching to file a revocation action on the 1st or the 2nd of June, and they do so, then you will not be able to opt out thereafter. Once the court has jurisdiction, then you cannot opt out. So I don't want to overemphasize the need to opt out, or the importance or even the urgency, but it's worth saying that that is the reason why we're filing a lot of them right now. We can carry on filing them beyond the 1st of June, but it's just a feeling that there will be law firms out there, ourselves included, who are mustard keen to file revocation actions after the 1st of June, get in there early and try out this new court, and you don't want to be on the receiving end of one of those. Gerrit, any more?
Nope.
The other takeaway, I think, is that it's going to be fast, it's going to be reliable, it's going to be predictable, much more predictable. It's going to be much better than Italian courts or French courts or Belgian courts. So it is going to be exciting, yes.
Excellent, brilliant. I think that's a great place to end today's webinar. Once again, thank you very much to our panel, Hugh and Gerrit, and thank you to you for being with us today. I wish you all a lovely rest of your day. Goodbye.
Thank you, Dan, for hosting. Thank you all for joining.
Bye.